This is Dave Pellegrinelli from TitleSearch.com. Today we're going to be talking about quiet title actions for our customers and customers for our friends at Foreclosure.com. A quiet title action is an important type of legal process to understand. It's basically a lawsuit to resolve unclear ownership or specific claims on a property. The reason why it's important to know is that for a foreclosure investor, when you purchase a property, you may be purchasing it for cash or using some alternate financing where a title insurance policy may not be required. When you go to sell the property to an end user after you've rehabbed it or you're retailing the property, you may find that that end user has a difficult time getting title insurance. The underwriter may require that a quiet title action is required to clear some title issues before they'll write the policy. Basically, a quiet title action is a lawsuit to resolve an ownership or claim that's unclear or ambiguous. To file a quiet title action, the plaintiff in the case must hold some reasonable right to the property. In some states, it's required that the plaintiff has possession of the property. The result of a quiet title action is a court order that will uphold or establish one party's right of the property. It basically extinguishes or quiets other parties' rights or claims of rights on the property. It's necessary when a property has records which are not definitive or conflict with one another. For example, if there's an easement that is not clearly defined or it's contested by one of the parties. Sometimes probate records are not very clear when a property owner passes away and the heirs' claims conflict with the title claims. Ambiguous records or even adverse possession can require a quiet title action. The way that it works is a lawsuit is filed by the plaintiff. Notices are sent to all possible parties with interest. In most jurisdictions, it's required that a record of the quiet title action is published in the legal organ for that jurisdiction. The action also requires certain elements of the case to be included. For example, a clear description of the property, identification of the party who is seeking the rights, a description of the rights in the quiet title action, and identification of possible cross parties who may claim adverse rights. Again, this is a legal issue that you should have an attorney look into. It's something that normally takes 3 to 6 months. So if you're a foreclosure investor and you plan on rehabbing a property and selling it, you should look to see if you need to have a quiet title action long before you try to sell the property. Because what happens is if you market the property, you list it with a realtor, it goes on MLS, it may take you a few months to get an offer, you have a contract. Now your buyer realizes they need title insurance and a quiet title is holding that up. You may lose your buyer if it's going to take 3 to 6 months to quiet the title. So you may want to start that process right when you buy the property, so once it's rehabbed and done and ready for retail, the quiet title action is complete and you can close your sale.